Well, Your Honor, I'm feeling a little bit ambushed here today. We'll start with what happened from my perspective. We attended the hearing on May 4th. It was Mr. Torres' first motion to compel, and the court ordered, the orders were we have 10 days to comply with discovery by the book. There was no specific order about separating responses, but granted that is by the book discovery. So we went ahead and complied with that. We provided our supplemental production and the three responses to interrogatories on May 18th. And then I didn't hear anything on this until I saw this motion to compel that Mr. Torres filed on May 28th. Now, when I read it, I wasn't sure what we were going to talk about in court today. Under the section one, by the time we get to the second paragraph, I'm completely confused. It says on March 10th, the court held a hearing on plaintiff's motion to compel. We had no hearing on March 10th. My compel was on April 20th. Mr. Torres's was on May 8th. So I'm not sure which one. The next line, order the plaintiff to strictly comply. I can assume we're talking about his motion to compel that was on 5/8 now. Documents to be delivered by March 18th probably means May 18th. I can figure that out. Again, we provided our supplemental responses on May 18th. Under section 2 of his second motion to compel, he only lists really two complaints with the discovery. The first is that plaintiffs have failed and refused to respond to interrogatories in any form. But as Mr. Torres has noted, we provided three responses to interrogatories, one for each plaintiff on May 18th. So that one doesn't seem relevant here. Second, it complains that they have further failed to file their responses to the request for production as required by the Texas Rules of Civil Procedure. I don't think there is a filing requirement. I certainly provided them to Mr. Torres. So from my perspective, I haven't heard anything. This motion to compel, I wasn't really sure what was missing. Going to the back here, the certificate of service is not signed. There are two certificate of conferences here. In one, Mr. Torres signs that he's the attorney for plaintiffs, but doesn't list a date he conferred with us. On the second certificate, he lists April 13th as the day he contacted our office, which was prior to his first motion to compel hearing. I reviewed my emails, I reviewed the phone log. I have heard nothing about any deficiency since I delivered that supplemental response on May 18th. If there may be problems,
Okay.
no, that might be true, but like you, I got this summary today. It sure would have been helpful a couple weeks ago.
It's taken quite a bit of work to compile a detailed summary of relief and to go through this discovery. As the court's aware, we, as small offices, we have a big burden to do all these things ourselves. And so I have had to put in significant time in between a lot of cases to identify these problems, Your Honor. But I think my response would be that the court's orders were pretty clear after our last hearing on May 4th. And the fact remains that we still have plaintiffs' responses that are non-compliant with the requests.
Again, I would go back again. No certificate of service, no conference, despite the certificate of conference signed by Mr. Torres. I have no deficiency letter, and I didn't even know what the problem with was discovery until this email came in that I opened at the start of this hearing. I go back to say the court ordered us to comply with discovery. I thought I had. I will note that in my notes, I don't have anywhere where the court ordered specific responses to interrogatories. I think his second and fourth complaint were related to the sufficiency of the evidence on supporting our damages claim, and supporting the defamation. I think the validity of evidence, the veracity of it is really an issue for trial, or if Mr. Torres preferred a motion for summary judgment. But I think we've been compliant. I may need to review the discovery to make sure my clients are protected at trial and we can present evidence. But I think we have complied. Mr. Davis reviewed this discovery on the way out because we had already had problems with it the first time and signed off. So,
Okay.
if there's issues, happy to rectify them, Your Honor. I just need time and some notice. That's all.
Well, okay, see, and here's the I mean, you've identified the half of the problems. And that is that I'm looking at the motion filed on May 28th. Then there's a second motion to compel filed on June 3rd. Defendants motion to compel reduction of attorney's fees, invoice, and supporting billing records. So what's that one about, Mr. Torres?
I'm sorry, Your Honor? The second motion?
I think this is the second motion has to do with your challenge of the sanctions I imposed on you earlier, right?
Yes, Your Honor, and that's something that I spoke with Mr. Mark Davis about. I filed a motion to respond or to request the court to address the issues that I had requesting the invoice. If the court can recall, I had spoke with Mr. Andrew Davis about this prior, just saying that the invoice that was provided to me had several entries that were not related to the discovery. So I asked for them to just resend me that invoice, and there was just a refusal to send me that invoice. And so I filed that motion based on the case law that I found in my research, stating the requirements for attorney's fees and the problem that I was having. Just to protect my clients, Your Honor, I just wanted to go through the invoice and make sure that what was being claimed was actually being charged. For example, Mr. Davis had said during that hearing, and that's not before the court today.
And yeah, it's not. I was just kind of going because I needed to clarify, that I was looking at the same motion that Mr. Davis was referring to. So you're right. We don't have to go into that. I just was clarifying the differences in the two filings. But and yeah, your motion to compel is rather limited on what the issues are. That was filed on May 28th. Mr. Davis, you acknowledged you received it on May 28th. That was 2 weeks ago. And so I'm wondering why we haven't had a conversation, because that seems to be the defense here is like, hey, nobody called me, nobody talked to me that there was a problem. We'll be happy to fix it.
Your Honor,
But go ahead. Go ahead. No, Mr. Davis, go ahead.
now you're right. I don't think I did try and call Mr. Torres in the last 2 weeks. He's usually available by email. I have a hard time getting a hold of him by phone, but I think what this really comes down to, Your Honor, is Mr. Torres trying to find a way to discount the attorney's fees for his clients that were ordered on our first motion to compel. It's all centered on that. He was asking for after the fact, after this court ordered attorney's fees on our first motion to compel, he wanted to check the invoice and review it and all that.
Yeah.
All things appropriate to be done at the hearing. If he has case law where he can file a motion to compel to get the invoice again and look at it.
So hold on.
But
yeah, no,
it remains unpaid. That's where I'm going.
Yeah, well, that's fine and dandy, but like Mr. Torres pointed out, that's not before us here today. I made my ruling on that. I could change my ruling on that. I could reduce it. I could be a little more lenient. I could do all sorts of things on that. But I'm not looking at any of that. What I think is happening is that I granted the plaintiff's motions to compel. It was kind of sloppy responses on Mr. Torres's side initially, and then we held him accountable for that. I seem to remember that there was some, and you weren't there, Mr. Davis. Your partner, your co-counsel, Mr. Mark Davis, was there, but I seem to remember some offer to the court that that there had been some what I would describe as a better working relationship with you, Mr. Davis, as we were going along, that there were kind of gentlemen's agreements on what was going to be provided and how and when, and you were all working well together until you weren't. And that's when Mr. Mark Davis kind of walked into the picture and saw the deficiencies in the responses and, took the appropriate measures to get that rectified. That it is what it is. But I think that left Mr. Torres was saying, okay, fine. If we're going to follow the rules, we're going to follow the rules, and he's going to play hardball back. And so it may have prompted him to be playing hardball, but if the responses are not compliant with the rules, that's what his motivation was or not. That's not for me to decide. What is for me to decide is whether your discovery is properly responsive and whether they abide by the rules of procedure. And that's it. And maybe the relationship was more amicable, more collaborative before. Now it's not. And so you have to bring me in to make some of these calls, and I have to do that. So regardless of those things, I have this discovery in front of me. I have this motion to compel in front of me. I have what the summary and the complaints are. I think Mr. Torres did a good job of summarizing some of it and showing some of the things. And a lot of it did touch on the things that I was requiring at the last hearing. I think I'm the one who initially said by the book, or, the rules are the rules and we have to do them. So I think that was the thing that I wanted to impress upon everybody, that the rules are there for a reason. And I didn't sanction at that time. I gave the opportunity to the plaintiff to do that. I don't think creating 3 copies of the same answers and having the 3 plaintiffs just sign off on them as their own is within the spirit of the rules. Okay. And when you're asked, tell me how you were defamed, and you give the same canned response by all 3, it just logically can't be possible, right? Not all 3 of the plaintiffs are giving the exact same answer, because they all were impacted differently. They all saw maybe different things. And so you have to individualize the responses when you have multiple people on one side. Especially for a case like this that carries certain elements to prove it up. So I think you would agree with me, Mr. Davis. You seem like a reasonable man, that you just don't push copy 3 times and then have each one sign off on it and then you're done. And you're saying Mr. Mark Davis looked this over, and if you're telling me he was okay with that, then there it is. And I think one of the other things I said at the last hearing is that I recognize a couple of logistical challenges that are involved, and I don't want to be kind of heavy-handed with it. I recognize that you all are small offices and may not have the support staff to get you through it, but the first set of discovery responses from the plaintiffs to the defendant were rather messy, and that, Mr. Davis, you acknowledged was unacceptable, and that you would personally go through everything. I don't know if you did this time or not, but I don't think we've gotten there yet. I don't think we've achieved compliance with the rules.
I think that's fair, Your Honor. You're right. I acknowledged it the first time. I reviewed the responses to requests for production, because that was a huge USB full of everything. I didn't see the interrogatories, but I acknowledge that. We like compliance. I'm a real big believer in Rule 199, where parties are to confer. I think a lot of this should be handled outside the court. And, this excellent summary of requested relief, I sure could have used that to correct this earlier. Again, I'm not really a discovery. I'm not really play game with discovery attorney. So.
And I don't see you as a lawyer that does that, but it's happened, and it's happened twice now in this case by the plaintiffs. So I don't know what the logistics are in your office, but it's now twice that I'm looking at some discovery that's not responsive. At the end of the day, that's the decision. Is it responsive or not responsive? And it could be non-responsive, as if the answers are not complete, or there's no answer at all, or whatever's provided is not in accordance with the rules. So, let me look at the motion for the request for production, on the request for production, because you said that's what you did review. I do see.
That one, I think that one, I was, when Mr. Torres and you were going through them, Your Honor, a bunch looked cut off and all that. And I think that's just something that happened in the process of printing. So I think that that is a problem. And I was not aware of that, that it went out like that with them. Because I did see while you were scrolling through them and I was looking through that we have a bunch of problems. We have the USB here. I can easily deliver that to Mr. Torres, but I did see that on the.
Yeah, but the other problem with that is that some of it is in Spanish, untranslated.
That
So
is a problem I have
they're
been
not
trying.
tied to a specific plaintiff. Who owns the business? I know there's it goes around a body shop kind of business. Who owns that?
They're two body shops, Your Honor. The plaintiffs own,
Well, who, all three plaintiffs own a body shop?
I know it's for sure Raphael Sr. owns it. I don't know if it's a partnership or an LLC with him and his wife, Sarai. Erica is an employee of the body shop, as I understand it.
And daughter, I take it.
And
Okay.
Todd, yeah.
Yeah. And then there's a second body shop owned by Rafael and Crystal.
yes.
Yes.
Okay, so
Well-
on that first body shop, let's talk about that. You're claiming defamation and fraud. How would the employee, how is she affected? She's an employee. I mean, is she taking it personally? Are they targeting her? And then
I
you
might have to
all-
look, Your Honor. It may be structured under an LLC. I'll tell you right now.
Okay.
Yeah.
Well, but they're suing individually for individual personal torts against them personally. So that's what's missing. A bunch of pictures of rude social media posts doesn't tell me how each one is affected by it based on the claims that you are making. So even if I saw pictures that are not cut off or blurry or and a lot of that stuff isn't even made by the defendants. There's a bunch of other third-party commenters, and then there's some of it's cut off, but it looks like other people are posting it. You know,
Yeah, it's all very difficult for me. I don't speak Spanish, so it's been quite a
okay,
so
so
and figuring out what they say.
I am going to grant the motion to compel again. Let me pull up the motion to see what relief is.
And Your Honor, I would just reiterate again the kind of the lack of notice I have on this, the certificate of service, the lack of a conference, but I won't take up your time.
And I think for some of the same reasons I didn't sanction you the last time. And you personally said, I will personally look through it. This is unacceptable. And you know, if I felt you had absolutely no clue on what the issues were with me and the responsiveness to the discovery, if you were completely caught off guard, I would certainly take that. But I just, given the past discussions we've had on the same requests, the same materials that should be there to support your claims, I'm having a hard time concluding that you're completely caught off guard. You just kind of waited for the hearing, and then we're going to stand on, hey, he didn't call me to confer. And I don't think that's necessarily fair to me. And let me see.
Well, really, because I think on his motions to compel, it was darn near unreadable. I mean, I could probably put together what I think it was for, but it's hard to say I was on notice of some of these issues. But I understand the situation, Your Honor. I know I sent to you an order for your consideration for attorney's fees resulting from Mr. Torres's motion to dismiss that the court found unmerited.
Oh, the 91A motion?
Yeah,
No, it wasn't 91A. It was the citizen participation thing.
Yeah, that's the one. What I was getting at is I'd be happy to withdraw from consideration that order for attorney's fees on that. Just I know I don't really like lawfare, and I think we're getting pretty far down the road in this case on it.
Lawfare, is that like similar to warfare?
Yeah, like procedural technical argument to avoid the merits in cases, you start arguing
Oh, we're
it.
not gonna avoid the merits.
No, no,
I want to get.
I know we won't. I really don't like going back and forth with motion to compels and trying to get attorney's fees on any little misstep or anything back and forth. That's what I was saying. When I saw the second motion to compel, I submitted that order for attorney's fees on that for the court's consideration. But what I'm saying is, we just drop that. Forget that. I'm not.
Okay.
I'd like to move this case along.
Well, that's up to you. It's on, you just said it on the record, so I'll
I'll
put
stand back.
I've written it down as well. What else do you have to say, Mr. Torres, about it?
Well, regarding Mr. Davis's request for fees on that motion, I don't believe that was before the court today, but the issue that I'm having, Your Honor, it certainly wasn't motivated by a retribution or trying to anything other than making sure that I do my job for my clients and properly am able to defend their position in trial. I mean, Your Honor, this is a case where my clients are being sued for $5 million, and it's very important to them that I make sure I do my due diligence. And of course, we're not asking for any unfair treatment. We were asked to comply with the discovery rules. We're simply asking the plaintiffs to do the same. And of course, my clients are very involved in this case, Judge. And so their involvement in this case, to the level that they are, give them a very deep understanding of what we're currently before the court for. And so I'm certainly here just representing to the court and Mr. Davis that the reason I filed the second motion is because we still have the same problem and I'm not able to prepare my defense. And the relief that we requested, Your Honor, was of course anything that doesn't comply with the rules be inadmissible in trial. We've asked for the attorney's fees. We've asked for compliance with the rules of discovery and for each plaintiff to provide individualized answers. One of the things that I did put in my summary of requested relief, Your Honor, at the very end is if the court would consider asking the plaintiffs to make a chart or something that would identify each plaintiff, which exhibit applies to each plaintiff, have them bait stamped so that I can attach each one to each plaintiff, and the financial documents necessary to prove their damages claim, and exclude at trial anything that's not in compliance.
Okay. So,
It's a good idea, Mr. Torres. I'm going to work on that chart. I wrote that down.
how much time do you, well, you're gonna need to amend your responses also. The chart would be helpful to sort of.
I mean, I don't mean in lieu of, Your Honor. I just think that's a really
Yeah.
nice idea. I wrote that down.
And I think it'll help you guys too, sort it out
I think it will.
and get yourself focused on what you would need to prove in court for each plaintiff. So let me think. The thing about your request for production, you answer them like interrogatories. They're asking for or communications and documents, and then the answers are explanations on why you don't have certain documents, but they're all kind of like interrogatory responses.
I think I think I'm just gonna have to amend it all in one clean response for everything, because my goodness.
And then I think the separation of each plaintiff is important. Each one has to stand on their own, and if they're signing off on it as being their own, that's a problem for them. It's like attesting them to be true, and if ever asked, you know, it's perjury. Let me see. One moment. Duties would send to plaintiff, drafted summary of request and relief. The motion to, the motion for sanctions, or the new, on the second motion to compel and the request for attorney's fees, I think is including the work on the first motion to compel.
Yes, Your Honor, that is correct. I mean, the invoice that is attached as my Exhibit 8 does cover essentially everything that I've done from the first motion and the second motion. I did put the dates though on what work was done after our first motion.
Yeah. There is a line that says, reviewed exhibits sent to plaintiff. That would be work on your responsive documents to the plaintiff on their discovery to you. So I'm not sure if that's something that can be counted here.
I'm sorry, Judge, which entry?
On April 22nd, 2026, reviewed exhibits sent to plaintiff. So you sent the plaintiff exhibits and you reviewed them.
Oh, no, I'm sorry, Your Honor, that must have been an error by my paralegal. It's a sent by plaintiff. It's that B right before.
Oh,
And yeah, because that was going through the exhibits and to the interrogatories and the production, and going through all the posts, identifying which ones were duplicates, which ones were not legible, which ones were, well, the problems within each one, and that's what I had to go through to take my notes to create the detailed summary requested relief. For example, there's beginning on page beginning about page 6 of my summary for requested relief, I go through the detailed exhibits that are not legible and the problems that we had, and it continues to identify which ones are duplicates, why I'm not able to identify which plaintiff it applies to.
okay. I'm gonna grant the motion to compel. I'm gonna grant the motion for sanctions. A revised responses to both interrogatories and the request for production for each of the 3 individual plaintiffs have to be provided to defendants by July 8th. Gives you 3 weeks. Is there a concern, Mr. Davis?
Not for me. I see we have bench trial on 8/4, so maybe on.
Yeah, we're gonna need to continue that because you haven't even started depositions.
Yeah, Judge, and that's one of the issues that I was also going to bring up. I'm not able to proceed forward on my depositions without these.
You haven't done depositions, you haven't mediated. I don't know if someone's gonna file a motion for summary judgment after all discovery is done.
So are we continuing that bench trial now? And maybe we can get.
I'm thinking you are. I hadn't noticed the date, Mr. Davis, until just the second that you're pointing that out to us. Let me see. So the bench trial, it's a bench trial on August 4th. That gives you about a month to do everything you need to do, including depositions and mediation. So I think, yeah, you're not gonna be ready. It was you're not going to be ready. And I want to give some time for any dispositive motions filed, motions for summary judgment. If this case doesn't need to go to trial, we won't go to trial. But you guys decide once the discovery is all cleaned up.
Well, the 7/8 production date will work fine for me if, assuming the bench trial is getting moved, it sounds like it is.
Yes, sir.
That's something else I can't think of, man.
Okay, that's gonna happen. And I'll probably kick it down to like November to give you the time to continue litigating. But if I can tell you that if the discovery is not responsive or corrected on your 3rd try now, things are gonna get struck.
I can imagine.
And yeah, things are gonna get struck, and I'm gonna grant attorney's fees to Mr. Torres in the amount, and I'm looking at the amount of time spent on each of these things. I'm looking at his
I would just
hourly rate.
I would just like to remind the court the amount of things that went into the plaintiff's motion to compel for an award, and the award on that was $23.50. It remains unpaid, but I think there was quite a bit more story to that one before we got there.
I don't understand what you mean.
That first motion to compel, the plaintiff's one, had been filed in, I think, November. The hearing had been reset 3 times, trying to work through it, trying to talk to Mr. Torres. The discovery, when it was sent, was a data dump then. So I'm not contesting the amount of time Mr. Torres spent on it, but it seems like the amount of discovery, the amount of the things that went on before we got to the hearing where attorney's fees were awarded, it was all a lot more. There's a lot more to it at that hearing, and that award was $23.50 that remains unpaid. Like on Mr. Torres's attorney's fees invoice, I see he reviewed the exhibits the first time on 4/22, that was 3 hours, and then on 5/20. Where is it? On 5/20, he reviewed the second set. It was 4 hours. It was, I mean, the same documents, only more organized. I
would respectfully disagree with that. I mean, they were labeled about more organized. That's exactly my issue. Is I had to go through the entire stack of the interrogatory exhibits, the entire stack of the production exhibits, and then I had to go and to prepare my summary request for relief. And to be clear about what I was asking the court and what my issues were, take essentially detailed notes on going through each one. And then each plaintiff had the same or different stacks. And so I had to go through the 3 different stacks for each plaintiff, also the supplemental production that was given, and take individual notes on all three. And so because it was a voluminous work to have to review and to be able to provide the detailed summary request for relief, Your Honor, it required me to go through this and roll up my sleeves, and that is why, to ensure that my issues were properly identified, that is why my summary request for relief was 19 pages, because I had to take notes on all this and to make sure that my arguments were clear on it. And I was also surprised that my summary request for relief had gotten so lengthy, but I did my best to go through and identify exactly which problems we had on each individual answer, not only for the court to review, but to aid the plaintiffs in what issues I had with each individual answer. And I'm really content that the work that I did to organize that would save Mr. Davis and his office time on going through and identifying which problem there was, because I've gone through to provide a detailed list on exactly what the problems were with each answer.
Okay, I'm gonna award attorney's fees for the second motion to compel. And it's gonna be in the amount of, based on the invoice,
Hey, Julian.
$2,800. And I mean, this is on both sides. You know, I said it with regard to Mr. Torres's discovery responses. I don't know if they've gotten cleaned up. I don't know. I mean, I haven't heard anything on that side of
If
the
I think if we're going to
situation.
lawfare, I'll have to file my motion to compel, Your Honor. Well, that's all right.
Yeah,
Enough
I'm gonna end up dismissing this if no one's gonna play by the rules.
for another.
We can't be going back and forth like this. And I will award attorney's fees even to the defense, because the case might be dismissed, but it's not going to be without a judgment on attorney's fees to the plaintiff's counsel. And I don't think you're providing any service to your clients by stalling this case just on, we can't put our ducks in a row to prove the case, to prove our defenses, to challenge the case. This is kind of on the ridiculous side now. It's so sloppy, guys. I'm listening to you, I'm hearing you, and there are no substantive objections to any of this stuff. No substance, that's all about form. Only because we're letting it leave our office a mess. And if that's the way you want to practice law, there's going to be consequences, at least when it hits my desk, to both sides. So it could result in a dismissal, but both sides are not going to walk away unscathed.
Understood,
So-
Your Honor. I think the last thing was, were you going to issue an order to mediate this?
Yeah, it was probably part of your bench trial order, but I'll
Okay.
give you a direct order by a certain deadline, which will put you on track with the discovery, the depositions, and the mediation, to just give you a firm deadline way before trial, so that that's the date you work towards. And then you can decide on your own if any certain depositions are necessary or not necessary. And of course, if you decide to resolve your differences even without mediation, that's fine too. But mediation has to be completed by a date certain that I'll provide you. Once Woody gives me the new trial date, I'll work from there, and hopefully we can work through this.
Thank you, Your Honor.
Your Honor.
Okay, anything further by the plaintiff?
Nothing further.
Anything further by the defense?
Nothing further, Judge. Thank you for your time.
All right, thank you both. Have a good rest of your day.
Likewise, Your Honor.